In the meantime, I want to take this opportunity, though, to bring in our special guest this hour. We have presidential pardon expert Tammy Allison and criminal defense attorney David Bruno, two of my favorites. I see what I have to do. I have to fill in for Michael Ayala when he was in my shift today to be with both of you, because this is a case I've been waiting to talk to you about. This interrogation, David, let me start with you, because you're a criminal defense attorney. How do you take, or what do you think about this 10-hour interrogation video that we've been watching?
I'll tell you what, the pretrial motion on voluntariness was critical here. Because look, the arguments about voluntariness and this lengthy interrogation really goes to whether or not it's admissible or not. And then once the judge rules it's admissible, it comes in. And look, it's going to be a tough argument for the defense to make. Right here, just before I got on, you heard the detective say that mile marker 13 victim, the information just came in right when he was being arrested. And he wants to say, like, I was privy to information I wouldn't have known. I knew stuff, and that's why I was spilling what I was spilling right there. And if that's a new investigation that was not known to anybody at all, that's really critical to showing that the information came from the killer and not somebody that learned information from another source.
Oh, wow, what a great point. That's why you are a criminal defense attorney, my friend, because I have to tell you, you know, as a former judge and having to listen to both sides and rule on facts based on the law, I'm struggling with this interrogation video, Tammy, for this reason. Classic interrogation techniques, but when you're watching it over a long period of time, I think, is the jury going to get frustrated with the prosecution, with law enforcement? Because you saw he got emotional in part of the interrogation, and when they got emotional after that is when law enforcement came in and said, you just need to help us out. Just help us out here. You need to do the right thing. Tammy, classic techniques. Will it be off-putting to the jury, in your opinion?
You know what, Judge Ashley, thank you for having me. I am agreeing with David here. I think that this is critical information for the defense, because I think it will be off-putting to the jury, given the fact that this is a 10-hour-long interrogation. And the fact of the matter here is they had to start really putting that pressure on him once he started showing that emotion. But that brings into question the timing of the interrogation. We know that the last person that escaped was September 2018. He was arrested around that time. No arraignment within the 48 hours as required by Texas rules of criminal procedure. But we do see on the docket that there was an indictment in December 2018. He wasn't arraigned until January of 2019. So some of those procedural defects could also be off-putting to the jury, and something that the defense attorney should raise. And it's very interesting that I have a case of an individual currently before this exact same judge from Webb County, where these types of issues is what I am pointing out in the writ of habeas motion that I'm writing on behalf of my client.
Wow, I know that's right. That reminds me that you do have that case you just referenced in front of the same judge, same courtroom. Now, the next disc has started. I need to get back in there, but I so appreciate both of you. You're staying with us. The next disc of the